University student charged for publishing fake information about the president is now suing Kenya's biggest telecom company for 200 million shillings. This is Kenya News Update today. Coming up, you'll discover how a dismissed criminal case turned into a massive privacy lawsuit and what it means for every Kenyan with a phone. Meet David Mokaya, a university student. On February 20, 2026, his lawyer announced a landmark lawsuit against Safaricom. But here's the twist. This isn't about fake news anymore. It's about whether your phone company can track you and share your location with the police without a court order. And the answer will affect millions. David Mokaya was charged for publishing false information about President William Ruto, but the case was thrown out. Trial magistrate Caroline Mugo at the Milimani court dismissed it, stating Mokaya had been framed by police who acted illegally. She told the court the police had no evidence directly linking him to the offense. He was released under Section 215 of the Criminal Procedure Code. But here's what nobody's talking about. The police allegedly got his location from Safaricom. And then something shocking happened. Instead of walking away, Mokaya and his lawyer, Danstan Omari, decided to fight back. They are now suing Safaricom for a staggering 200 million Kenyan shillings. Here's the part that will blow your mind. Lawyer Danstan Omari accuses Safaricom of violating the Data Protection Act by allegedly sharing his client's location with police without a court order. He claims the telco giant undermined Mokaya's dignity and right to privacy guaranteed by the Constitution of Kenya. This is a violation of a fundamental human right. We shall be moving to the High Court because our client's constitutional fundamental right was violated. We have demanded 200 shillings million. We shall also be asking for legal fees to be provided by Safaricom because this trend must stop. But the stakes are even higher. Omari further disclosed he would seek guidance from the court on whether DCI officers were allowed to confiscate suspects' phones and other gadgets. The question of police officers arresting people, and the first thing they take is a handset. No law allows police to take possession of phones until a court order is issued. He hinted he would follow up on other cases where police arrested suspects after mobile service providers disclosed their location. The lawyer has issued a demand letter to Safaricom, giving it up to Monday to pay Mokaya the money. He maintained that officers from the Directorate of Criminal Investigations were not allowed to request mobile service providers for the location of Kenyans without a court permit. This case creates a seismic shift. Some say this is a brave stand for digital privacy. Others say it's an attempt to profit from a dismissed criminal charge. But if the police acted illegally, where does that leave the evidence they collected? The implications are huge for every Kenyan. Your location data, your call records, your entire digital life could be accessed without a judge's approval. This lawsuit could redefine the balance between national security and personal privacy in the digital age. But here's the unanswered question. If Safaricom shared data without a court order in this case, how many other times has it happened? Do you think a 200 million shilling lawsuit is justified to protect Kenyans' privacy? Or is this a misuse of the justice system? Drop your take in the comments. This was Kenya News Update today. Subscribe for more breaking news that affects your rights.